will recall that I had a motion that I filed before trial entitled Motion to Prohibit Speaking Objections, and that was intended to prevent what was going on yesterday, where the prosecution was going on at length about the problems with my questions and why it wasn't proper and on. And I think early on it was apparent what the basis for the state's objection was, and I don't think it was appropriate to argue it at length in front of the jury in the manner that it was argued. And I think it's that sort of thing that can be ultimately prejudicial in the case.
Well, let me just say that unfortunately I don't always pick up on things as quickly as I maybe should. So sometimes it's necessary. Sometimes it's also necessary to have a little bit of disagreement, or maybe not even disagreement, but explanation in front of the jury. I do agree with the general concept. I didn't invite your response, but I assume that you, well, why don't you say what you want to?
Well, I think I've been rather succinct, Your Honor. It's and I haven't perceived any problems with the manner in which I've stated my objections. I indicated that I objected and what in the grounds for the objection, and the rule requires that you object and you state the grounds for your objection, and I think I've done that. Now, I don't believe I've gone any longer after that than Mr. Albee has.
Well, as I say, I didn't detect anything that I considered beyond over the line so far, but I agree with the general concept that you expressed, that objections need to be kept as succinct as possible, and if I invite further discussion, then we'll have it, and if it gets to the point that I think then we need to get to excuse the jury, then we'll do so.
And second, Judge, I renew my motion. Actually, my motion is to strike testimony of Dr. Michael Chambliss on the grounds that no notice was provided of his intent to offer expert testimony regarding ethylene glycol, or probably more importantly, on that cause of death would be suffocation, and then the previously argued argument that it went beyond his expertise to testify about ethylene glycol. My concern about the suffocation opinion is, again, no notice, and for 9 years, or at least 6 years since this case was charged, there's been one single theory for the prosecution. The whole time it's been ethylene glycol, ethylene glycol, ethylene glycol. They've tried out expert after expert to say ethylene glycol. We had a forfeiture hearing, it was ethylene glycol. And then they bring in an expert without any notice at all to say, after getting 5 minutes of information, to say, no, it's a suffocation. I wasn't prepared to cross-examine on those issues. I didn't have learned treatises available on those issues. I haven't had an opportunity to explore hiring an expert more specifically in that area, and didn't have the opportunity to consult with an expert, or the expert that I already have retained in this case, in the manner that I would have had I known that expert opinion was forthcoming on the issue of suffocation. And even for that matter on ethylene glycol, which I have spent some time on, I was caught unawares that he would be delving into that issue in the manner that he did. And so I would move to strike Dr. Chambliss's testimony, and in the alternative, move for mistrial.
Thank you, Mr. Chambliss.
Well, Your Honor, first of all, I would say the vast majority of the testimony from Dr. Chambliss regarding ethylene glycol was elicited on cross-examination by Mr. Albee. There was some on direct, but the vast majority of testimony regarding ethylene glycol was elicited by Mr. Albee. And if he didn't think the witness was qualified, I guess he shouldn't have asked him the questions. With respect to the issue of suffocation, first of all, there was testimony during the forfeiture hearing from Dr. Mainland that she believed the primary cause of death was ethylene glycol, or that it was at very least a significant contributing factor. But she also testified that there was nothing inconsistent with the findings at autopsy with a death, with a smothering or suffocation death. contrary to, I mean, it is true that there's been very little discussion among the, and very little in the reports regarding a suffocation death, but that was certainly a suspicion that Detective Ratsberg and I had when we arrived at the scene, and that's one of the reasons that I was so interested in what Aaron Dillard had to say when he described the manner in which, when he described the statement that Mark Jensen gave to him. I felt that the physical evidence precisely corresponded to that. Now, in terms of the testimony of Dr. Chambliss regarding smothering as the cause of death in this case, again, that was testimony that as I recall, was really gone into on redirect examination after a cross-examination. So it was counsel that was asking the witness repeated questions on cross-examination regarding cause of death. And it was certainly something I was permitted to go into on redirect. And I think that some people have this perception that because of the extensive exchange of information that occurs, primarily from the state to the defense in advance of trial, that they're entitled to a surprise-free trial. And that's not the case. This is not a scripted event. We don't follow a script. And the fact that we try to convey as much information in advance, and even during the trial, I mean, during the trial, I've been very cooperative with defense counsel, trying to make sure that he knows what's coming up next. I tell him who the witnesses are going to be that day. We've certainly not withheld anything. And it really was something that I observed during the cross-examination of Dr. Chambliss when he was testifying at greater length, much greater length, about these injuries to the left anterior chest wall, that I looked at these photographs again that were taken at the crime scene, and it refreshed my recollection because I'd remember seeing her arm in that awkward position. And that's what caused me to pursue that again. I honestly didn't know what Dr. Chambliss was going to say, although I have to say that when you put all that stuff together, it doesn't seem like it takes a rocket scientist to draw the almost inescapable conclusion that Julie Jensen was smothered in the manner described by Mark Jensen to Aaron Dillard.
Well, I don't know if it takes a rocket scientist or who it takes, but this case has been pending for 9 years, and nobody came up with a theory until yesterday when Dr. Chambliss
Now, it seems to me that I read that in Detective Ratsberg's questioning of the accused.
He was lying. He was lying.
No, I'm not just saying that, but the question is, no one came up with that theory. Well, Detective Ratsberg explicitly asked about that theory when he questioned the defendant before this charge was ever brought.
But it was established that he was lying to Mr. Jensen in an effort to coerce a confession.
I didn't get into a discussion of whether the statement was truthful or not. I was getting into the fact that there was that theory banging around out there. And the police at least suspected it. I assume that the reason, and he can speak for himself if he's asked about it, and I have no doubt that he will be, Detective Ratsberg, Lieutenant Ratsberg, I assume that the reason he asked it, lying or otherwise, was because he suspected it. So this is not a new theory, but that is first raised at the time of the trial. So go ahead.
Well, and there's mention of Dr. Manlin, page 67 of her testimony on August 1st, 2007, line 8, question, in your opinion is that this is not asphyxia as cause of death. True answer, yes. And the criminal complaint says ethylene glycol. Everything has been ethylene glycol, and that this is the reason why we have the notice of expert opinions more so than something else. Even if it's relying on these photographs, those photographs have been viewed by Dr. Manlin, by Dr. Lavin. They've been available the entire time, and to Mr. Jamboys. And the reason nobody came up with that theory is because those photographs are misleading. And in terms of the issue of what I raised or that I talked about ethylene glycol to a greater extent than the prosecution, I'm sure that's probably true. I'm obligated to cross-examine him so he can't perpetuate a fraud on the court that he's some kind of expert in ethylene glycol when he doesn't know anything about it. And so I had to cross-examine about it after it was presented. And so those are my concerns about notice. I wasn't prepared in the way that I would like to be. And, you know, it's a murder case. And now the state has a cause of death from an expert. That is like the central issue in the case, and we've had the case pending for 6 years, and now I don't get any notice of it. It comes during examination, during the first witness at trial.
Well, let me respond in a couple of respects. Number one, getting back to the qualifications of Dr. Chambliss to testify in the manner that he did, we have to keep in mind that this man was performing the functions as medical examiner, and his credentials are certainly viewed as being superior to that of the average individual. You quoted yesterday from the federal rules, and I think we have to recognize the fact that the Wisconsin Supreme Court has consciously rejected employment of the federal rules. This is not something that is out in legal limbo out there. Our Supreme Court has stated we don't want to follow that course and has a very liberal policy, and it's subject to a lot of debate, but it's our law, and I have to follow it. And it says, basically, in layperson's language, that if the expert can impart knowledge greater than that which the average person has, that's the basic test. And I'm oversimplifying it, I know, but what do I know about Doctor? I know he's a physician. I know he's a pathologist. I know his credentials were sufficiently adequate that he was appointed as a medical examiner whose job it is routinely to make these kind of determinations. And I know that he knows a lot more about ethylene glycol than I do, or about asphyxiation than I do, and I understand I may know less than the average juror, but I don't think it's such an enormous gap. And what I know about ethylene glycol, first of all, I did not know prior to this business coming up that it was the principal ingredient in antifreeze, maybe the only ingredient, I don't know, but and I did not know, I knew that antifreeze was poisonous, I guess, but I didn't know how it was poisonous, how it affected the system, what it would do to the kidneys, the blood, the bladder, the brain. I didn't even understand some of the terms that were used here yesterday, and some of them had to be spelled. I don't think anybody else who hadn't studied up on the case knew that. He had a lot more information about these things, about how various toxins act on the body. And he also saw the other, he made the other observations about the, I'm thinking, petechiae, which are symptoms that we in the criminal courts are fairly familiar with, but I don't think the average person is familiar with, and about whether injuries as were found on this lady were likely post-mortem or not, and so there's an enormous amount of information that he has which is far superior to the average person, and I think his credentials are sufficient to allow him to venture the opinion that he did. And if and there's an array of other experts who are going to come to the witness stand, and the jury can, if there's contrary opinions voiced, will be allowed to weigh those against what he has to say. And I thought, without, I don't want to get into too much of a commentary, but I thought you did a very, I commend you on the thoroughness of your cross-examination. So the jury will have a lot of information to deal with and make, I think, a fair and conscientious decision about his credentials. With respect to the lack of notice, as I pointed out, this theory has been out there at least since Lieutenant Ratzberg questioned
And excuse me,
the accused.
The counsel did quote from the transcript of Dr. Mainland's testimony, and I believe he quoted selectively. And if you look at page 67 of the August 1st transcript through 68, Dr. Mainland says on line 21, there's no doubt that in my mind, you take the history, the toxicology, the totality of the whole case, there's no doubt that Julie Jensen received a lethal amount of ethylene glycol and died of that. Like I said, there are things to support asphyxia, but I can't prove it. Question, well, and this is on cross-examination, well, what findings would support asphyxia? Answer, there were some hemorrhages in the neck that may or may not be suspicious. They may be simply post-mortem artifact. I just don't have a good enough description or good enough photos to make a decision on them. So, Dr. Mainland was not ruling out asphyxia. She indicated that asphyxia is typically a diagnosis of exclusion, and that there was other evidence in the record that supported the finding of death by ethylene glycol. But she did indicate that there were findings at the autopsy that were consistent with asphyxia unless otherwise explained away.
Did you want to respond?
Well, she said she can't prove it, and she also, much more candidly than Dr. Chambliss, acknowledged that these things could be post-mortem artifacts, something that Dr. Chambliss repeatedly denied.
But
So
whether he denies it or not, that's not the test as to whether it should be admitted.
that's the kind of thing I would have been prepared for, I think, had I known that
But
there's
you
going to
did
be.
examine him about it.
Pardon me?
But you did examine him about it.
I examined him, but I didn't know anything. I didn't have a learned treatise or something to use with him.
Well, I think, getting back to the point, and I think Mr. Jamboy's point is a good one too, but we know that asphyxia was an issue, if not, I understand it was not the claimed cause of death initially, but it was certainly an issue at the time that the defendant was interrogated. When was that? In 2000 and...
He was
1999?
April of 1999, Your Honor.
99. We know that since Mr. Dillard you became aware of Mr. Dillard, it was known that the state was going to contend that asphyxiation was the immediate cause of death. So this is no surprise. And I don't think that's a convincing argument.
I'll have to say, I was surprised that the state has thrown out 9 years of their medical experts' testimony for a convict like Aaron Dillard.
That's not the test of admission.
And that's not what the state has done.
And I can be surprised that they chose to go that route. I don't know. And I'm not saying I am. I'm saying that's got nothing to do with admissibility. It's got nothing to do with striking off evidence. And ultimately, you are suggesting the court should be put in the position of either declaring a mistrial and starting all of this all over again, which would be very, very disruptive. And, well, I don't even want to go into that. Or denying any innovative thinking taking place at all during the trial and just running it off of as if it were a recording. That's not the purpose of these notice statutes. The purpose of the notice statutes is to guard against an unfair ambush. But there are plenty of in-trial developments in major cases, in minor cases. The trial itself is a pursuit for truth, and for us to suggest that it's got to come in some sanitized form, that's poppycock, and I'm not going to go down that road. So, and I'm not going to spoil the trial because of this. Because for starters, I don't think that there's anything improper been done. I think you've known about this since it was clear. Mr. Jamboys gave up the October trial date because he wanted to have these witnesses available. And I'll be honest with you, well, I'm not going to say anymore. That made rather evident the importance he attached to it. And at that time, at least from that time, you knew very well that he was, if not electing asphyxiation as cause of death then, he was making it very clear that he had that option available to him. So I'm going to deny your request. Anything else?
No, Judge.
Anything else?
No, Your Honor.
Would you ask the jury to come in, please?